Welcome to the American Constitutional Society's event on the School to Prison Pipeline. Thank you all for coming. We have 3 really awesome panelists here today. I'm just going to introduce them really briefly and then show a 10 to 13 minute-ish film that features all 3 of them about this thing that we're talking about today, just so that you guys have a little bit more of an idea of what we're talking about. So first we have from Duke, we have Professor Jane Wedek, you're the director of the Children's Law Clinic, is that correct? We have Judge Marcia Morey, who's the Chief District Judge for Durham County, is that correct? And Jason Langberg, who's the supervising attorney for the Advocates for Children's Services with North Carolina Legal Aid. And they're all great, and they're all going to talk after we show this quick movie, which is from the Duke documentary. It's from Duke. It's about the school to prison pipeline. They're all in it. It's cool. We're going to watch it for like 10 minutes, and then we're going to get down to business. We were supposed to have a 4th panelist, Barbara Fetters from UNC. She's stuck in court today, so she's not going to be here. But these 3 people will be more than enough to fill our time and attention. So thank you for coming.
Keep holding the children responsible. You not this, and you suspended from school, and you kicked off the bus, and you're not this, and you're not that. Here's your pink slip, over and over again.
So that students slip through the cracks, and then we either see them out on the streets or we see them locked up.
I know what it does to a child's self-esteem. It's tragic because I know what the outcome will be.
Children are great at one thing, and that's making mistakes. That's the nature of growing up.
We got it wrong. We got it all twisted.
Virginia's 7th grader and his friend suspended.
9th grader was suspended for wearing rosary.
20 Northwest High School students have been suspended today.
And 9 Huntsville students were suspended today.
Are sending tens of thousands of students into the criminal justice system every year for violating school rules.
America's schools are suspending and expelling students in record numbers due to a rash of zero-tolerance discipline policies and an increased presence of security officers in schools. Together, these practices are pushing large numbers of our most vulnerable children out of school and into what educators, advocates, lawyers, and judges call the school-to-prison pipeline. The pipeline operates in almost every community, most likely yours too. This is how it works and why we should all be concerned.
I think suspension has become kind of a default move for many school administrators, that it's kind of quick, it's kind of cheap, and it's kind of easy to just kick kids out of school.
Change who you are, change your mentality, change how you handle conflict. I guess change the person that you are.
We readily admit there's misbehavior that happens in school. No one argues that that should go unaddressed or that we shouldn't ensure school safety for our kids. But the solution isn't to kick kids out.
Make some better choices.
It's not distributing drugs at school. It's not bringing weapons to school that are the most common. In fact, those serious offenses account for only about 5% of the suspensions. And the rest of them are for disruptive behavior, disrespectful behavior, smoking in the bathroom, things like this that maybe are against the rules. But should we really be kicking kids out of school for these kinds of things? It's just not productive.
The first time I got suspended was in the 3rd grade for a fight. 4th grade was a fight. I got suspended every year after that. I got suspended in high school for having candy in my book bag. Attempted to sell.
A 2013 report by the American Academy of Pediatrics states, out-of-school suspensions are harmful to child development, and when used too readily are ineffective deterrents. Suspensions often place the child back into the environment that may have contributed to the antisocial behaviors in the first place, thereby negating the effectiveness of a lesson learned.
I haven't found any evidence that school suspension is an effective discipline tool.
Yet, North Carolina's schools issue close to 260,000 suspensions each year.
We see kids who in first grade, they have missed 20 days of school. They're placed in second grade, they miss 40 days of school. They're just shoved on.
All right.
Oftentimes, they're shoved into the court system. This is made easier by the presence of security officers in our schools.
We need to treat kids as they are. We need to give them a chance in life.
Good evening, everyone. The reaction of so many people today was, oh no, not again, another high school.
After the shooting at Columbine, school boards across the nation hired security officers. In combination with a zero-tolerance discipline mentality, the presence of police in our schools has contributed to an alarming trend in which students' routine misbehavior is treated as criminal conduct.
With zero tolerance, it says if you do something, you'll be suspended. It's really strict, it's really rigid with respect to what teachers can do in using their discretion in handling situations in the classroom.
In Wake County, for example, the authority of armed security officers often eclipses that of teachers and principals. They have the power to search students, their vehicles and lockers, test students for drugs and alcohol, plan and carry out canine searches, and much more. Many students feel like their schools are under siege. Studies show that the presence of security officers has led to a dramatic increase in arrests for minor infractions, like talking back to a security officer.
I think it's backfired. I don't think it's made schools safer at all. The intended consequences have totally been turned on its head.
A typical example took place at Broughton High, when two girls got into a fight over a boy. Instead of being taken to the principal's office, the girls were handcuffed, placed under arrest, and put behind bars.
We got fingerprinted, and we got a mugshot picture.
I've never been arrested. I don't get in trouble. I don't understand. And it was terrible.
I think about 40% of the cases we see in a juvenile court are school-based offenses.
And we're seeing clients like mine who are in second and third grade being referred to court for things like throwing pencils, and who are being suspended dozens and dozens of times in second grade for doing, in large part, what we would expect a second grader to do.
Studies demonstrate that children most harshly affected by these disciplinary practices live in low-income minority communities, and the data is disturbing. It shows that black students are 4.2 times more likely than their white classmates to be suspended or expelled for the very same infraction. As a result, black students lose 4 times more school days than their white counterparts. For minority children living in poor communities, the role of the school has shifted from a ladder out of poverty into a pathway to prison.
It doesn't make sense. We got to get better. When all this fighting, alcohol, drugs, all this stuff is going on around this child who's a sponge, who's soaking this up, and you want him to go through all this dramatic stuff, and then the next day I'm supposed to get up and go to school and function like I'm a normal kid, like that nothing happened. Good morning to you. Good to see you again.
My mama had a drug problem, back when I was younger. She wasn't really around like that. And my sister, she was only 1 year older than me, and we kind of looked out for each other. I grew up in a house where it's every man for himself. You got 13 people, but you living for yourself. I could never buy no food and put it in the refrigerator because people might eat it. Man, there's been times where I went to the corner store, had to steal food just because me and my sisters both had to steal food because we ain't had nothing to eat, you know what I mean? And it's been plenty of times where we had to look out for ourselves, and we'd be in elementary school, you know what I mean?
Nobody processes that with these young people. So they get up the next day and is expected to go and sit in a classroom, and they still traumatized from the night before. And then you want to say, well, why aren't you paying attention and get out of my class and you're not listening? When did we become so desensitized that we can't relate to people?
Thousands of kids cuffed and kicked out of school in Colorado. And now tonight, an effort to do away with those zero tolerance in schools.
It would be the biggest overhaul of school discipline in this state in more than a decade.
Down the road from Columbine, the city of Denver is working to dismantle its school-to-prison pipeline.
It eliminates mandatory expulsion except in cases of guns, encourages districts to limit out-of-school suspensions, and requires schools and police to report disciplinary measures taken by gender and race.
Since 2003, suspensions have dropped 44%. Expulsions fell 57%. The number of students referred to police plummeted by 63%. Denver is not alone. School districts across the country are changing their punitive policies and investing in additional support services instead.
You stay humble, you put your best face forward.
A handful of schools in North Carolina, like this one, are following a new national trend.
Before I got here with the programs, it was a high turnover rate in terms of suspension. The principal requested me to come over, and because I knew I worked with her at another school, and she saw the success of the program. Stay focused, girls, stay focused.
With a behavioral specialist at their school, teachers remove disruptive students from their classrooms and send them to in-school suspension. There, they'll face consequences, but they'll also receive the personal attention and support they need.
What I want for every child, and young adult for that matter, is to see that they are this great person. You know, even though you act a certain way, that doesn't mean that's who you are. And really help them see that you have everything that you need within to be the person that you aspire or want to be.
Yes, ma'am. I'm so proud of you.
With guidance from teachers, Curtis, who was repeatedly suspended and even arrested in high school, was able to climb out of the school-to-prison pipeline. He's now thriving as a student at Wake Forest Technical College. Meanwhile, at Broughton High in Raleigh, the girls who were arrested for fighting over a boy did not go to court because a Campbell Law School professor, John Powell, intervened.
And it sounds like it made a big difference.
Powell persuaded the court to allow the girls to enter a peer mediation program he runs with his law students.
We reached in and we snatched them out of that system. And so we snatched them out of the school-to-prison pipeline.
It helped a lot because we came so far from what has happened.
As soon as they begin to connect on a human level, the conflict begins to fall away. It's beautiful to watch it happen. That's what we call the magic.
Even in the poorest communities like Roanoke Rapids, educators developed an off-campus suspension program called Families Supporting Families.
Okay, guys, let's pull it together. Let's get it, let's get it, let's get it.
In Durham, another education leader operates a school that attracts dropouts. The teens are given another chance to earn their high school diploma.
S equals D over T.
But programs like these are scarce in North Carolina. Unless educators and community leaders take action, the Tar Heels state will continue to push thousands of children each year into the school-to-prison pipeline.
I think just realizing that it's a problem will help out, because most people don't even know the problem exists. Unless you grew up in it, you may not even know it exists.
Everything needs to be done. Work with these kids. They're minors. Their brains are being developed. They are impulsive. They do have issues. But we need to educate and help them rather than push them in this pipeline.
I think it's up to everybody to get involved, all the way from the state level down to the local level. The practical reality is that to really have comprehensive, meaningful reforms, we've got to have our students and our parents and our educators at the table leading the way in crafting those changes.
Hear from our three panelists. If you guys want to come up here and take a seat. Yeah, so I introduced them briefly before the movie, but I want to give them an opportunity to introduce themselves in a little more depth to sort of tell us about what it is you guys do and how your work has interacted with these issues of the school to prison pipeline that we just talked about. So in whatever order you want to go. Go ahead.
Hi, everyone. I know you're here for the free lunch and the movie, not us, but we're glad to be here. I'm Marcia Morey. I'm a Chief District Court Judge here in Durham. I've been on the bench 16 years, starting my 5th term next year. So I've been working with juvenile justice for over 25 years. Started as a prosecutor, worked with our governor to change the laws in North Carolina to reform our juvenile justice system. And now just primarily am a big advocate, as you saw in the movie, and wanting to educate people about this issue, and especially all of you that are ready to go out and start a legal career to really think about some of the social issues that are really impacting our country today.
And I'm Jane Weddick. I'm here on the faculty, and I teach education law as a course that's opened in the fall to any 2L or 3L that was interested. And then I direct the Children's Law Clinic. So the Children's Law Clinic is one of our clinical programs. We focus on education issues in the clinic, and one of the areas that we deal with is school discipline. So typically we get involved, and I see a couple of former clinic students who handled some school discipline cases, and one who's in the clinic now is all I see. But the way we work with this issue is both on an individual level and on a more systemic level. But on the individual level, when a student, like the student you saw in the movie who says, I used to get suspended, if a child is facing a suspension of more than 10 days, that child is entitled to a due process hearing. And our law students in the clinic will represent the student in that appeal hearing. And that can be first in front of a teacher panel, then in front of an appeal in front of the school board. And on rare occasions, it can go up into the state court system. So we just work individually to try to keep kids out of that system by helping them minimize the amount of time that they're out of school. The clinic's also taken on some other matters. I was personally involved in getting our state's school discipline law revised a few years ago to get rid of some of the most egregious parts of it. And like you heard about the Denver program, we no longer have automatic zero tolerance in North Carolina except for guns. So that was a big change to not have a lot of automatic suspensions. So we've been involved in some issues like that.
All right, so my name is Jason Langberg. I am a supervising attorney and director of the Push Out Prevention Project, which is an initiative of Advocates for Children's Services, which is a project of Legal Aid of North Carolina. So really I work at Legal Aid. And we at Advocates for Children's Services focus on education justice and dismantling the school to prison pipeline. So how does it relate? It's pretty much all day, every day. And we do that in 3 ways. So one, we provide legal services to low-income families who are experiencing school push-out. So denial of enrollment, unmet special ed needs, unaddressed academic failure, suspension, expulsion, mistreatment by law enforcement officers in schools, discrimination, any way that the school system is pushing the student out, we work with those families to step in and intervene legally. I also do a little bit of immigration and domestic violence, but just a very little bit. And then the other 2 things that we do a lot of community education. So we do a lot of trainings for students and parents. We probably do 5 or 6 a month on what their rights are and how to advocate for themselves. And then we train service providers on how to help families be successful in school and how to spot issues and then refer us cases. And then we do a lot of publishing materials, either self-help materials or fact sheets, issue briefs for different districts across the state about this issue. And then lastly, we collaborate with a lot of folks, including Jane and Judge Morey and others who are working on these issues, and including grassroots community organizations that need our help in sort of advocating for their local communities.
Great. So I just wanted to get a little bit into school policy and what kinds of policies, discipline-wise, have you guys seen in school systems that have contributed to this sort of school to prison pipeline have contributed to making it happen, and what specifics have you guys done in terms of looking at these policies, making recommendations for changing these policies, anything you guys have to say about disciplinary policy within the school districts that you've worked with?
Well, why don't you start, because you've done more of that than I have. I've done some.
Okay. So the primary discipline policies we see are the overuse of suspension. And by overuse, I mean using it for things that shouldn't result in suspension, things that should be teachable moments or opportunities to provide positive interventions and supports for kids. Out-of-school suspensions for things like truancy or having saggy pants or non-compliance. These really minor offenses that when you suspend a kid out of school, even a short-term suspension can result in really, really harmful academic failure, behavioral and emotional issues, and an increased likelihood of ending up in the juvenile and criminal justice systems. So that's the biggest discipline issue we see, is the overuse of that policy. And then within that, of course, we see other issues like inadequate due process for kids being suspended from school. And then the other big one, I think, is school policing issues. We have across the state roughly 1,000 or so law enforcement officers working full time in our schools, called school resource officers. But make no mistake, those are sheriff's deputies and police officers who are patrolling, usually armed with pepper spray and a taser, and without much training or regulation or accountability. And so they're put into the schools with the law enforcement mentality into a totally different type of environment. And like I said, without many restrictions. For example, there's no restrictions on being able to refer kids to court or arrest them for something they're doing that's a result of their disability, or for arresting or referring to court for something very minor. We don't have restrictions like that on our SROs like they're doing in some of the more progressive districts across the country. And so when we get these cases, what do we do about it? We like the Duke's Clinic, we provide individual zealous advocacy for those families to try to fight for them in the suspension hearings, to file internal affairs complaints against those law enforcement officers. But we do so with an eye towards systemic impact. So even on behalf of one family, we'll file a state complaint over a special education issue or a federal civil rights complaint. We've done 4 or 5 of those in the last few years on behalf of individual families, but asking for systemic relief from various agencies or in the courtroom, I guess. And then, with law enforcement, we'll file grievances with the schools, and then some of the other punitive disciplinary measures that don't have as many legal protections, like in-school suspension or transfer to alternative schools, or even in some districts still corporal punishment, we can help step in there and fight for those families as well.
One of the things that I think is important is to recognize how much power individual school districts and school boards have on this issue. And so one of the things that I've started to do is, after I've had an individual case, however it came out, I have started, sometimes it's resolved at a level that doesn't really get to the school board. So we'll have the hearing and the suspension will be reduced and our client is okay. But then I'll just write to the school board and I say, I'm not complaining about this particular case, but this raises an issue. And in the last one that I did, this was a child, high school senior, whose car was subjected to a canine search in the parking lot, and the dogs alerted, and the cops decided that there was marijuana residue in the floorboards of his car. They did not collect it, they did not test it, they did not produce it. They just came to the school hearing and said he had marijuana in his car. This was a second offense for him. He had been suspended for marijuana use 2 years before, and therefore he had to be out of school for the entire rest of this was in October, for the entire rest of his senior year for this marijuana residue on the floorboards of a car that he shared with 4 uncles and a variety of other people in his family. And I just thought the school board should know that the message they're sending to the principals is, this is a child who has to be out of school. Now, I have no idea whether they think that's the right message. I'm hopeful that they actually were kind of horrified that that was going on in their school district, that a child was losing his entire senior year in high school for residue of marijuana on the floorboards of his car, with no more evidence than that. I actually don't know how they responded. They just acknowledged my letter politely. But I think if that's the kind of thing that if they hear that more often and get some pressure from communities that this is not what we want our local school board to be doing, that maybe those messages will get changed from the school board level down to the principal level. And it's the principals who are really the ones who are deciding on an individual basis because they have a lot of discretion. They could have given that kid a 11-day suspension or an entire year suspension. They have the discretion with that broadly. And so that's just one example.
That's it. And I guess with that, we also send letters to the board. We also try to go to the media as much as we can when we feel like we can spark their interest. On the cover of the Indy Week this week, there's a story where we try to connect our clients with the media. Often they end up focusing on the lawyers, but with the idea being that's a forum for clients to express themselves and to draw attention to issues that otherwise legally get resolved below the school board, kind of lifts them up for everybody to pay attention to. So check out that article as an example of one of the cases we're working on with policing, with the clinic, and with some other organizations.
I guess I'm on the deep end. I'm in the court system. So if it doesn't work with what Jane and Jason are trying to do with local schools, we get them in the courts. You know, we don't ask for cases. They're given to us and we see them. So the school to prison pipeline, think of it as two pipes. It comes from the schools, but it goes in the adult criminal system or it goes in the juvenile system. And in the juvenile system, 40% of all the complaints on an average come from the schools. And as Jane said, a lot of times it's like, this kid really has needs. What resources can we get him or her? Well, put them in the court system. They have resources. We can get them on probation. We can get them the mental health assessment. We can get them substance abuse assessment. We can get them the curfew. We can get their parent court order to be involved in it. So even though the behavior, was disorderly conduct, there's so many needs of this kid, file a petition in juvenile court because they have needs. So what does that petition do? It is a court document. It alleges that child, 7, 8, 9, 10 years old, to be delinquent. Do you think that's a stigma or a label that just vanishes as soon as the court session's over? No. How many of you have heard, oh, he was in juvie? You know, word gets out. I mean, that has an indelible impact on a young child. And they got into that place because they had needs. They needed services. The family didn't have the wherewithal. So how do we find the solution? Slap on a delinquency complaint. It's the wrong way to go. Juvenile court should be for kids under the age of 16 who have serious offenses, community safety. That's what courts should be about. But as I said, hundreds of cases in Durham every year come in for misdemeanor minor offenses on these young kids. We get them the services, but the damage has been done because we didn't take care of it at the beginning where we should have. The other pipeline, to me, equally as serious, if not more so. North Carolina is only one of 2 states in the country. On your 16th birthday, if you commit any criminal offense, it's not juvie, it's the adult criminal system. And believe me, sitting in the adult criminal courts, every day I see 16-year-olds, 17-year-olds charged with minor misdemeanor offenses, particularly shoplifting, possession of Schedule 6, underage drinking. So a citation goes out by the officer, and a warrant goes out by the officer. That is not confidential. That is public record. Even if they're found not guilty, even if they're diverted to teen court or some other resource and it's dismissed, that arrest record is indelible. And when you're 16 years old and you have that arrest record and you're wanting to get your first job, you're wanting to apply for financial assistance in college, you're wanting to go into the military, pretty much you can forget it. The impact is dramatic. North Carolina, we have worked hard year after year to convince the legislature, be like most every other state, raise the age of jurisdiction for adult criminals up to 18. Every year it fails. We've been doing this for probably 15 years. It's going to come back again from the General Assembly. So it's critical. And we're talking, this is society. This is how do we raise up these kids to be responsible adults? Well, our system is saying we don't care, and particularly on the disproportionate minority conduct. I look out in my court every day in Durham, 3 miles from here, and I see basically a courtroom filled of African Americans. And that charge, even though it was minor, and I had a 16-year-old walking into school, put a piece of gum in her mouth, threw out the wrapper. Officer saw her, he was patrolling on the street, stopped his patrol car, ran up to her, said, "What is that?" Well, I think she gave him a little attitude. He wrote her a citation, littering. 16 years old. Gets the citation, court dates on the citation, she throws it away. She didn't come to court. Officer was there. That night, he went to her house. He waited for her to come home, took her, put her in handcuffs, took her to the magistrate, gave a $500 bond. She spent the night in jail. She was released the next morning because she failed to come to court on the littering of a gum wrapper at 16 years old. That arrest record stays there unless it gets expunged, which is resources and money. So, I mean, the consequences are huge and they're severe. And so I hope you're aware of this issue and, you know, the things that are being done to try to change it.
Yeah, and so can you guys hear me if I just sit here and don't set up the microphone? Okay, awesome. So you talked, Judge Moore, you talked a lot about the raise the age issue, and that's something that I know you and I talked about, Professor Weddick, when I was talking to you about this event. So I want to know if you or Jason have anything to say with regards to that campaign, the raise the age issue, which you very laid out in a very nice way.
I have not gotten as involved in that issue just because the clinic doesn't handle juvenile and criminal stuff. So I'm more aware of it simply as an important issue in our community, other than on a personal level and raising it with my legislators. But I do think, however, at the school level, one of the things that can be done is for the school boards to be more in charge of messaging to the school resource officers to tell them and give the message, sending kids through the criminal system is a last resort. It is for weapons. It's for serious safety issues in school. It's not for kids being disrespectful and the minor offenses that it's used for. And so again, I think where we can, we need to impact that at the legislature, and that's the only place we're going to have any impact is getting legislators elected who think that's wrong and are willing to vote to change it. But we can also minimize it, I think, at the school level. And this is one of the things, there was a reference to the Denver school board. And the school boards, again, have this power to say to their employees, their superintendent and their principals, this is not what we want happening in our school district. And there are such serious consequences in the state of North Carolina, as Judge Morey has said, for kids that are 16, 17, 18, that are in school, that's sophomores in high school on up, going to the criminal justice system, that we need to minimize at the school how many of those kids are going into the criminal system and restrain the school resource officers and say, if you're going to work in our schools, this is what we want you to be doing, and this is what we want you to not be doing.
Yeah, I don't have much to add. I don't really focus on that issue so much, but it does intersect with our clients in a few ways. One is our state enrollment statute says that if you've been convicted of a felony, you can be denied enrollment. And so some of the 16-year-olds who go into court and end up getting a felony, even if it's not a serious felony, although that sounds to be like an oxymoron, then they can be denied enrollment, and that's a real problem. Some school districts try to do it even with a juvenile adjudication of a felony, but at least we have the language to play with there. And so that can impact the kids. I think most of the school staff that we come across, I don't think know this raise the age issue, and so I think if there were better training, not just on don't do this with the officers, but to the educators, the teachers, and the principals, don't do this because here's what could happen to this 16-year-old, and I think they'd be less likely to call in the police officer if they knew where that kid could end up. And then I think the last thing is something Judge Morey touched on, which is the public nature of adult court can then trickle into the school system. So if you see the 16 and up kids who are on the newspaper with their mugshots, or you see a high-profile story of a kid in a newspaper, even if the charges are ultimately dismissed or the kid's found innocent, a lot of times our communities are pretty small, and the school staff pick up on that and then start to watch our kids more carefully or stigmatize and profile them in some ways.
One other issue that I kind of wanted to touch on was touched on briefly in the movie, and Judge Morey, you touched on it as well, the sort of disparate impact of these disciplinary policies. You mentioned that you look out in your courtroom and you just see basically like African-American face after African-American face. There were some statistics that were talked about in the movie about children of color being X times more likely to be sent to be suspended for the same offense as a white child. What I'm wondering is the how and the why of that, and I think Jason, you do some work on this, right?
Yeah, I mean we filed discrimination complaints. We filed we did one in Wilson County when they just suspended a bunch of students of color for having saggy pants, hundreds of them all on the same day. We've done one in Durham for their disparate impact of suspension and expulsion on African American students, and one in Wake County about the same issue, and then more recently one to the Department of Justice about how school policing disproportionately impacts students of color and students with disabilities. But in terms of the why and how, I think it's really complicated. I think on the front line there's implicit bias in the staff and the folks at the school that results in some negative expectations or some assumptions about where kids are coming from. That doesn't get counteracted with cultural competency training or equity training or dismantling oppression training to counteract those implicit biases that everyone has coming into the teaching profession. I think there's an issue of students of color making up a disproportionate population of high poverty schools, which struggle to provide adequate interventions and resources and alternatives to suspension. And so because their schools are starved of resources, they oftentimes are the kids most in need of services getting the least amount of services. And then I think two other things. One is there's too much discretion in local school board policies in terms of who you can suspend and for what. And of course, with the law enforcement officers, it's do whatever you want all the time. But things like dress code violations, saggy pants, what does that exactly mean? Noncompliance, aggression, these are the types of offenses that we see disorderly conduct you mentioned, where we see a lot of the biggest disparities come into play because it's such a subjective offense. It's hard to write a board policy in a way that sort of narrows those classes of offenses, but it can be done better than it's done now, and there can be more accountability built in. So, for example, no district that I'm aware of, except I think Chapel Hill now, publishes their data for every single school's discipline rates. And then for an example would be having an equity team at that school that looks at those disparities in discipline and how to address it holistically in their school. We know from our state reports that we have whole districts that have massive disparities, but if you break that down for some districts, you'll see that it's a handful of schools that are suspending like 80% of their African American students. And so coming up with district-wide solutions isn't necessarily a priority. So all that is to say we need to do a better job with holding schools accountable for data specific to those schools. And then I think the last sort of why is historical, and how we saw sort of a spike in some of these suspensions in the early 70s, sort of right after all deliberate speed ended and we had more integration. Well, I don't know if we had integration so much as we had some desegregation. And there's some theories out there that this is in some ways a response to sort of resegregate schools and have and get back to the way things used to be.
More to touch on about that.
I do think in a lot of schools, it is a cultural competence issue a lot, and I see I just see some of the school staff responding to kids in ways that suggest that they have expectations, just cultural expectations for kids that there's no reason for them to exist. And I think that there are, there's a lot of racial tension in a lot of schools, and you get more of the staff is white and not as many African American teachers and principals in those schools. And so there's a racial disparity right there, and the authority figures being white and the kids being African American results in just some tension there that's part of our whole society, and it gets played out.
I remember before I became a judge and prosecutor in juvenile court, we had one particular middle school, and they kept bringing these charges in on marijuana, and kids bringing blunts, having them in the bathroom. And yet at the same time, at the same school, there was a group of white kids that were bringing Ritalin to school and selling it. And so we went over and we were having a discussion about this. Why are all these petitions coming in when suddenly they started talking about the white kids selling Ritalin, which is a Schedule II drug, which is a felony possessed with intent to sell and deliver Schedule II. But they called the parents in, they talked to him, don't let Johnny bring his Ritalin to school and don't let him sell it, the school nurse will have it. And yet they can go out the principal's door and everything's fine. I mean, that's part of a very concrete example of why we have disproportionate minority contact. And it's outrageous and it's an injustice. But I'll never forget that day of being there, hearing these two things, this misdemeanor class 3 and felony sell deliver Schedule II, and that was taken care of with the parents, and these are filed in court. Disproportionate minority contact.
I think one other thing that needs to be mentioned, surely there's someone thinking, oh, isn't that because the black kids misbehave more? That's a response that we get, I think, when we, at least I do, when we present to audiences. And well, first, there's no data to support that. I think second, even if that were the case, there are sort of more educationally sound, more appropriate alternatives to suspension and calling the police. So you're still having a disproportionately harmful impact on those kids without any real justification for it. And then lastly, even if you break down the data really narrowly in some districts, like when we filed the civil rights complaint in Wake County, we saw that even for the exact same offenses, the African American students were being punished more harshly. The same objective offenses. So cell phone use was one of the ones we put in the complaint because we were seeing about 3/4 of the black kids being suspended for using cell phones at school, but only 1/4 of the white kids for doing literally the exact same thing, just using a cell phone in class. So there's actually evidence to support that the opposite is true, that it's actually just a subjective bias issue.
Excellent. So my last question to you guys before I sort of open it up to whoever's left in here is, as young lawyers and as people who are involved in education and education policy, what kinds of concrete changes should we be advocating for going forward, like in our careers collectively?
Yeah, be aware. I mean, tackle issues, get passionate about it. I never thought in law school I would be passionate about juvenile justice, but what you start seeing as fundamental rights in our entire society, it can make you very passionate about it. And you've heard the problems. There are a lot of solutions, and it's trying to be creative about solutions. I've gotten the DA, the sheriff, the chief of police in Durham, we're ready to stop arresting 16, 17-year-olds for misdemeanors. We're going to try to stop that first criminal contact, get them in a diversion program, and rip up the police report if they're successful. Creative ways of how do we get around these injustices? How do we get around the system that's biased? And how do we get some new solutions? So,
for your practicing law, find a way to volunteer. Just find a way to get connected with kids. I mean, there's lots of ways to do it. Some of it's just on a personal level. Find a tutoring program, find a mentoring program. Or, I mean, you're developing great skills of advocacy here at Duke Law School, where you can go and either represent a nonprofit that wants to make a presentation to the school board or wants to make a presentation to other in terms of being able to be public spokespeople, write op-eds, go appear in front of the city council, go to the school board meetings, find out what's going on, become a school board member, become a city council member. You don't have to wait until you're 50 to do those things. Heard the story not too long ago of a guy who's now a lawyer, and he's an education lawyer, but he taught in Teach for America for 2 years after his undergraduate career, and he was so distressed by what he saw change. It was a small community, and the school board had a lot of power, and so there are lots of places that you can plug in.
I think the biggest thing, I think you said what policy or what change, and I think the biggest thing is our school system and our court system. They need money. They just don't have the money to carry out their missions. And it's not, most folks know we're one of the worst states in the country for funding public education, but most states are terrible. So wherever you're going to go end up, you can probably assume your state doesn't fund education enough, doesn't fund the juvenile system enough, and they just can't do this. So it sounds a lot like we're blaming schools, and sometimes that's the case, but more often than not, they're well-intentioned people who want to do the right thing, but don't have the money for drug treatment and restorative justice and small class sizes and great training for teachers. They just don't have the money. And the money's there, it's just not allocated in the right ways. So that's what I would say the biggest policy is, and the biggest thing you can do, I think, is practice public interest law. I don't think we need more lawyers making rich people richer, quite frankly. There's enough of that. There's enough corporate lawyers in the world. We don't need any more of them. We need more people out every day fighting for justice. I mean, if you go do that, do the stuff in your free time, but we need people doing this on a daily basis. And with Duke's loan forgiveness help stuff, and with all the other stuff that's out there, and with places even like legal aid that pay enough to, have a decent life, do this work. Don't go make rich people richer. That would be my plea. We don't need that.
Excellent. On that note, do you guys have any questions?
Thank you all for being here. Judge, you touched a little bit on this, but how much do prosecutors have the discretion to recommend different sentences, recommend different treatment programs instead of sending people to jail or filing these charges?
The DAs have a lot of discretion, and they get the charges that come that are filed, but the plea negotiation is totally within their discretion, and most things are pled out. But even if they go to drug treatment, or if they go to no active sentence, suspended, any misdemeanor almost costs $1,000 for anyone to take care of in the court system. If they do community service, they have to pay $250. They have to pay the court cost of $190. They have to pay their lawyer's fees of $55. I mean, you have to be pretty wealthy to get out of the court system without going to jail. So, but the discretion of the prosecutors is very great. And they can get them into diversion programs, first offender programs, so it'll be dismissed, or, it'll be that suspended sentence.
Yeah, I was wondering, for immigrant youth, do they also, first of all, experience this disparate impact? And then also, are there impacts on immigration status for youth who are referred through schools to the criminal justice system?
I'll start, and then judge can take the system one. So, yeah, we do see it. Actually, in North Carolina, youth categorized as Latino or Hispanic are actually underrepresented in most aspects of the pipeline. Sometimes we'll see the push out happen before, particularly for undocumented people, happen before they even go to enroll in school. So some organizations just filed a civil rights complaint over discriminatory enrollment practices. So maybe that those families don't even get in the first place. We filed a complaint in Wake County over Spanish-speaking families not getting proper access to interpreters and translated documents. Because in our eyes, that's a form of push out if it manifests in that way. And then there are consequences when they get into the court system, particularly if they're 16 and 17-year-olds. If you get arrested, ultimately you could get deported if you're undocumented. And it has consequences for parents. We have parents. A lot of our clients at Legal Aid, the ones we can represent, which is you have to be documented for Legal Aid, but the parents don't want to appeal because they may be undocumented themselves, even though the child was born here. And that's an issue because they don't want to raise red flags or draw attention to themselves, and their children are the one who suffers because of
them deported. And it's a red flag that goes up. And we have a jail full of people with ICE detainers, even though, they've resolved their case. It's a 48-hour hold without bond for the feds to be notified to see if they're going to deport them. So there's a big impact.
How do you feel about the teen court program here, Duke? Do you think it's helping or hurting, part of the problem?
The teen court program in Durham or at Duke?
Well, Duke is connected to it, but so how they...
Yeah, there are a lot of, it's great. I started that 20 years ago, and we probably run through 300-400 kids every year on Thursday nights, a couple courtrooms running. A lot of Duke students have come and helped those lawyers. Maybe you're one of them. Yep. But it's fabulous. And kids hear their own cases. And a lot of the kids that come now, more and more, are the high school kids trying to avoid the conviction. But we're trying to say, let's avoid the arrest that got them into teen court, because that arrest stays there. And we're hoping with our new misdemeanor diversion program, we're going to use teen court even more to get them in without the arrest, so once they comply, they'll rip it up. But the teen court program's fabulous, and I just hope it'll take that extra step to avoid that arrest record. And thank you for helping them out, because the kids really look up to y'all.
And I also had a question. We had, I've only worked there a few times, but we had some students who were in middle school, and there was one kid that stuck out to me because he was very clearly not the instigator. Like, some people had been playing around and stole a wallet, and he ended up with it. And he's this little kid who's obviously not a bad kid at all. And so, it still bothered me that he ended up in court, and he was, scared out of his mind, and he's, 12. And so, I guess, even with teen court, which is a great program to not arrest these kids, what else needs to be done to not get that 12-year-old who didn't do anything in there in the first place?
Yeah. And in teen court, the downside is they have to admit responsibility. Well, a lot of times it's like, no, let's get this over with, admit responsibility, go in front of the jury of your peers. I mean, it's traumatic to a little kid, especially like that. Right. That sounds like they should have investigated that a little bit more before they threw them into the teen court system.
There are districts in other states that have said you cannot file charges or refer for these certain offenses, and law enforcement has gone along with it in collaboration with the judges and the school system and advocates to say if it's this category of minor offenses, or I'm not sure if they flip it around and say if these major offenses you can, but they say you can't refer for these minor things unless it's like a third offense or unless there's been alternatives tried. And so that's one way of dealing with it, and I think the only real not even close to foolproof way of making it stop, of making sure it doesn't happen, because inevitably you're going to get some bad actors in the system who are going to go after kids. We've had kids 7 years old referred to court for stealing paper at school, and you're just not going to get rid of that because there are always going to be a few of those people, and so you have to have a policy in place that says no, you cannot refer those kids to court. And in the districts that have done it, they've seen really good outcomes with improved school safety, improved graduation rates, and narrowing of their racial disparities.
One more question.
Is there any particular offense that you think is disproportionately used to push people out of school that just seems ridiculous? Like maybe it's the cell phone thing, maybe it's possession of marijuana, I don't know. Is there one thing that stands out that if you could target the criminalization of that activity, you could make an impact?
Well, I mean, the ones we see, it can sound serious, assault on a law enforcement official or a teacher. I mean, that's an A1 misdemeanor, and then you read the petition, it's shoving. That comes in. The marijuana possession, the cell phone, the disorderly conduct, communicating threats, Yeah, there's a huge plethora of them. But I think what Jason said is interesting, that there needs to be a policy. These kind of things will not go one step further into the legal system.
One of the things, the small amounts of marijuana, to me, are the ones that these are not bad kids. And to put those, to me, small amounts of marijuana ought not to be school offenses. They ought not to be criminal offenses. If we as a society think using marijuana is bad, we ought to talk about why it's bad and what harm it is and put kids through programs, but sending them off to losing school and going off to the criminal justice system for really small amounts of marijuana, to me, is one of the ones that we could target and think about alternatives to responding to marijuana use, as opposed to criminalizing it and excluding kids from school because of it.
I think marijuana, possession of a small amount of marijuana, and assault, what they deem assault, are the two biggest that result in the harshest consequences statistically. And so if you had to pick one, I'd pick one of those two, probably that one, but if not, the assault one, to sort of mandate if there's no serious injury, or even injury, I guess you could say, then restorative justice is our mandated alternative, some kind of peer mediation, which is obviously so much more effective. So I think assault's the biggest category, and if you dealt with it in that way, I think if you had to start with somewhere, that might be the one.
All right, so we are out of time, but let's give our speakers a hand.